give me a minute. Whoever sat in this chair last was obviously, I need to be higher. That's better. Thank you very much, Neil.
Same for you.
Yes. Ms. Morris, I should say that coming along the corridor, I was asked by another colleague what I was doing today. I said, well, I'm doing a public procurement about the provision of orthodontic services. I said, it's really interesting. They looked at me as if I was quite mad.
Well, you're in good company again, because look at all of us.
Yes.
My Lord, what I propose to do is respond first to my learned friend, focusing first of all on some specific points that we should take from the authorities, dealing with this question of what is the relevant principle of European law that might be said to have been breached or otherwise in this case, dealing with the effective remedy point, and then turning to our points in our respondent's notice and including within them the rescoring issue. So that's the shape of what I propose to say.
Okay.
Given that my lords have indicated the extent of their reading, and which is clearly apparent from the dialogue this morning, I'm going to home in on one or two key matters. So just dealing with one or two key legal points. To go back to basics, what we're arguing about is the interpretation and application of Rule 98 in the procurement rules. And that is where it provides, and it's set out in our skeleton, that the court may award damages to an economic operator which had suffered loss and damage. And what my learned friend showed you in NHS Solutions in the Supreme Court is Lord Mance's explication of the work that the word may does. So it's, I won't take you to it again, but it's paragraph 39 of NHS Solutions in the Supreme Court, and that is at tab 23. What Lord Mance says is that the regulation should be read as providing for damages only upon satisfaction of Francovich. So the work that the word may does is say you only get those damages if Francovich is satisfied. And of course, that's a reflection of the fact that these regulations were introduced to comply with the directive. Now, what is the underlying principle behind Francovich? And we say that you can take that from Braceurself Ltd, which we include in our skeleton at paragraph 12. And it's something which reflects this balance between the interests of the individual, the aggrieved offerer, I think as it's been put, and the state. And that means that we are exactly in the territory that my lords have identified. We're not only concerned with what has happened to the tenderer, we're also concerned with what has been done, how and why by the state in that particular case. And it's Lord Slynn in Factortame which tells us how the courts in this jurisdiction should go about striking a balance between those two sets of interests. So if we turn up Factortame, I'm well aware that you've read it, but I quite like to take you to some of the detail of the language. So Factortame is in the first volume of the Bundle of Authorities at tab 10.
Yep.
We start with Lord Slynn at page 291. Oh, I'm being told you don't have these page numbers. Then internal pagination 542.
Yes, we've got copies of the report, so they've obviously got their own internal page numbers, but we don't have a page number for the bundle.
So Lord Slynn, internal pagination 542. Between just at F, the question which he identifies as being asked in this case is, can it be said that even if the Act of 1988 was deliberately adopted it was an unintentional and excusable breach which should prevent what was being done, what was done being a sufficiently serious breach in that it was a manifest and grave disregard of the limits of the UK's discretion. And what I take from that, my lords, is that the richness of the language which the Supreme Court used to articulate the different dimensions of the test. So there was a point at which it's been suggested it was only bad faith, but what the Supreme Court is telling us is to look at something with more dimensions than that. And you can see that again if you turn on to Lord
Just
Hope.
before you leave that passage, can I just ask you this point? One point Mr Moser made was the fact that there's a manifest breach and that should therefore be considered sufficiently serious. And you do see an echo of that in language there. Do you want to say anything about that?
Perhaps if I can break it down, if there is a manifest error, then there has always got to be a question of what principle has been breached and the nature of the breach, and then the rest of Lord Clyde's questions. So one can conceive of something which might be a manifest error in its obviousness, for example, but which isn't a breach of a fundamental principle or where there are lots of other sort of exculpatory factors. It's always got to be a matter of facts and circumstance, as Lord Clyde says. So just because there is a manifest error, you aren't catapulted into the terrain of damages. It's much more richly textured than that. And as I say, the reason for that is the particular character of Francovich damages. And Lord Hope acknowledges how that might make all of us used to the English and Welsh law somewhat uneasy. And he expressly acknowledges that the task of deciding whether the Francovich test is met is novel. And so we get that at the internal pagination 550 between C and D. It is a novel task. So it's not surprising that we all feel a bit uneasy because it's not something that we would ordinarily be doing in considering whether someone is entitled to damages. And then if you carry on towards the end of that paragraph between D and E, he says this: the phrase is sufficiently serious and manifestly and gravely, which the European Court has used, indicate that a fairly high threshold must be passed before it can be said that the test has been satisfied. So again, that reinforces this point that there is something more to be achieved if you are seeking damages within the Francovich framework. Then if you carry on to between G and H, he says this isn't a case where it can be said that the treaty obligations were obscure or that they related to matters which were of minor importance. I wouldn't go so far as to say with the Court of Appeal that the direct breach of a fundamental principle of the treaty will almost inevitably create a liability in damages. The nature of the breach will always be highly relevant factor in the assessment. The more fundamental breach, the easier it will be to regard it as sufficiently serious. So again, it's a matter of evaluation and weight. Then if you turn over the page to internal pagination 551, at C, Lord Hope says the third factor relates to the methods which were used to achieve the result. And he...
I'm sorry, I've lost the reference. Page 551.
551 at C.
C. Yep,
Sorry.
third factor. Yep.
Third factor. So he talks about what the state had done in that case, which of course we know was take a calculated risk, having had some advice. And so then between E and F, he says this then was more than a trivial or technical breach of the community obligations. Words manifest and grave are not easy adjectives to apply in this context, I've no difficulty at all in seeing that what was done here is a breach which was sufficiently serious, etc., etc. And then he says, just by F, if damages were not to be held to be recoverable in this case, it would be hard to envisage any case short of one involving bad faith where damages would be recoverable. So there one can see a scale and it being addressed what it was that had been done by the state. And in that case, it was this taking of a deliberate risk. And then he contrasts that at H with other cases where something might have gone wrong due to inadvertence, misunderstanding, or oversight. If you then, and I'd ask you just to keep that articulation in mind when we have a look at Delaney in a few moments. But sticking with Lord Clyde, who we have at internal pagination 552, and we've thought a lot about his articulation of the various factors. And if you turn then to 553 and 554, and the phraseology which has taken some particular focus is on 554 between D and E. So no single factor is necessarily decisive. One factor by itself might, particularly where there was little or nothing to put into the scales on the other side, be sufficient to justify a conclusion of liability. And then some of those factors. Now, what we say the court should take from that is that you might, in assessing in a particular case whether the breach is sufficiently serious to sound in damages, to alight upon one factor and say, that's really serious. But you cannot rely on that unless you have gone on to look and see whether there is anything else to put into the scales on the other side. There has always got to be a multifactorial evaluation. And so if one applies that in this case, for example, we've got the judge saying, well, items 1 and 2 weigh in the balance on Mr. Moses' client's side. It would have been wrong to stop there. This judge, like every other judge, is compelled to go on and consider the other factors, however weighty a particular combination of factors will be. You cannot do your job of applying Lord Clyde's factors unless you look at all of them. Then just to develop this point about the richness of the texture in relation to state of mind. And we have state of mind at the top of page 555, paragraph 5, just between A and B. And what Lord Clyde says is this: it's also relevant to look at the state of mind of the infringer, and in particular, whether the infringer was acting intentionally or involuntarily. A deliberate intention to infringe would obviously weigh heavily, notice weigh heavily but not necessarily decisive. An inadvertent breach might be relatively less serious on that account. Liability may still be established without any intentional infringement. So you've got a whole spectrum there, and then a second dimension to this factor, which is more broadly the purpose of the infringer should be considered. So that is not just was this intentional or unintentional, but what were you aiming to achieve? If the purpose was to advance the interests of the community, a breach committed with that end in view might be seen as less serious than one committed with the purpose of serving merely national interests. With that preamble, can I say that we should keep that articulation of the tests in mind when we look at what my learned friend seeks to take from Delaney and from Energy Solutions. Now, Delaney is at tab 20 in the second bundle of authorities. I beg your pardon? Well, I've got it behind tab 20, which for me is in my second bundle. I don't know which it is for everybody else. These are the judgments of Mr Justice J and then the Court of Appeal addressing his judgment.
Yeah.
And then if you turn within it, please, to internal pagination 5208.
5208.
And it has paragraph 113 at the top of the page.
113. Yep.
So just by C, what Mr Justice J does in terms of state of mind is he says that this is a case where the defendant must be taken to have decided deliberately to run the risk. So that's the state of mind of the infringer which arose on the facts in this case. Now, what is alighted upon by my learned friend is earlier in the judgment at paragraph 84, which is internal pagination 5201. So this is before he's made his determination at paragraph 84 at the bottom of the page, Mr Justice J setting out what he understands to be relevant factors. And what he says in the last couple of lines on that page is what it's important to recognise at this stage is that the test's objective, brackets, if a government acts in bad faith, that is an additional factor which falls objectively to be considered. And then the weight to be given will vary from case to case and so forth. Now, Lords, we say that phrase in brackets does not take away from that which has been said by Lord Clyde and his brother judges in the Supreme Court. We can see from what the Supreme Court said that bad faith is one factor, which of course is likely to weigh in a particular direction in the balance. But if one goes back to the Supreme Court, there's no suggestion that in the absence of bad faith, that is a neutral factor. We've seen from what Lords Slynn, Hope and Clyde say that there are a range of material states of mind. And to say, well, it's either bad faith or neutral is wrongly reductive.
Does Lord Clyde deal with bad faith? I can't remember. Don't know if you don't know off the top of your head.
I don't know off the top of my head.
Okay,
I haven't. Yes, he distinguishes that from bad faith. If we just go back, if I may, to what we're looking at.
Sorry.
No, that's quite all right. It's worth doing it. Tab 10.
Yeah.
Sorry, I've just got my own. It's for me page 300, which for you will be internal 551. Yes, it's fine. If you have a look at it, it's actually Lord Hope who touches upon, and he touches upon it at F on 551. I think I showed it to you actually a couple of moments ago. So that's bad faith.
It's hard to imagine any case short of one involving bad faith where damages would be recoverable.
Yes.
Yes, so it's, yes, I think I'm right, that Lord Clyde doesn't actually have it as, refer to it in those terms. And so at 84, what Mr Justice J is doing is dealing here with the Lord Clyde factors. And he is adding in the point in brackets.
Yes,
Yeah.
and so we say you should be cautious in treating that as a dilution or modification of the Lord Clyde factors.
Yeah.
Then if you,
What do you mean at sub Roman 3?
the seriousness of the breach will always be an important factor. Well, I take from that that relates to Lord Clyde 1, possibly Lord Clyde 2, i.e., you know, what is the principle that you've breached? But in my
I thought the whole
submission,
question was is there a sufficiently serious breach?
well,
Just presumably the seriousness of the breach is the question. Never mind, always an important factor.
well, what I'd be inclined to say is that given the facts as Mr Justice J found them, and given the location of this paragraph in his judgment, we should all exercise a degree of caution in using it to modify our understanding of what Lord Clyde said. But it's been doing quite a lot of work for my learned friend, and it was therefore important for me to show the court that it's perhaps not the clearest of articulations of the approach that we ought to be taking. If one carries on to what the Court of Appeal had to say in Delaney, and then if you turn then to internal pagination 5226, halfway down the page, in italics it says, the second issue is the breach sufficiently serious to give rise to liability, and they then summarise
That's the neat summary of the 8 points.
yes, and then at 36 they say the judge applied the multifactorial approach, so however he digested it in paragraph 84, he worked through those factors, and then they agree with Mr Justice J at paragraph 50 on page 5230 that the remainder of Lord Clyde's factors didn't weigh heavily in the scale, so they agreed with Mr Justice J as to the factors which he had identified as relevant. They said the other ones didn't weigh heavily, which we say is the right way of looking at it following Lord Clyde. And then what they did was, we say, give some helpful guidance, although perhaps it's clearly apparent, as to the approach that a Court of Appeal should take when asked to look at an appeal against a decision that a breach was not sufficiently serious. So if you have a look, please, at the top of the last page of the judgment, 5234, or in fact maybe at the bottom of the preceding page at 63. So the exercise undertaken by the judge at first instance will normally be the appropriate focus of attention, even if this court needs in the end to reach its own conclusion. And then carrying on over the top of the page, if there is no material error or omission in the judge's analysis, there will in practice be only limited room for disagreement as to the overall assessment of the seriousness of breach. So we say that for my learned friend to succeed on his sufficiently serious challenge, he has to find an analytic failure on the part of the judge below. And of course we say that there is none. Just picking up this theme.
Except to you that if Mr Moser was right on either of the, leave aside ground two for the moment, either of the two principles I put to him during the course of his submissions, that those, if he was right, those would be areas of principle that would entitle this court to interfere.
It would entitle you to interfere. Whether you would then say that overall the balance was
Yes,
wrongly struck is another question.
yes. But if, conversely, if he was wrong on those two, then you would say, well, the judge did the exercise, he didn't misdirect himself, so that's that.
So we say what Mr Moser failed to do is identify an analytic error. What we say he attempts to do is create a new principle or a new subset of cases along the lines that my lord has distilled in his two principles. And we say if he doesn't get home on establishing these two new principles, which we say are a deviation from the Lord Clyde approach, then that part of his case fails because there is no traction for this court on the judgment. So then, just yes, picking up my thread of let's stick with Lord Clyde and be cautious where others appear to deviate. Can I briefly take you, please, to Mr Justice Fraser in Energy Solutions, tab 22. And it's a point already made by my Lord Justice Snowden, but it's such a good one I'd like to repeat it if I may. So if you turn please to paragraph 61. So Mr Justice Fraser says the fifth and sixth of Lord Clyde's factors, namely the state of mind of the infringer and the behaviour of the infringer after it's become evidence that an infringement has occurred. You ask who is the infringer. He then discusses the position in relation to the infringer's witnesses. And then at the end of the paragraph, or sort of 2/3 of the way down, he says, there are therefore no findings that there was any deliberate intention to infringe in this case. And so if we then think back to the way that Lord Clyde and his brother judges considered it, the question of whether or not the infringement was deliberate was not the beginning and the end of the court's analysis. There was more to it than whether or not it was deliberate. But what Mr Justice Fraser does is, we say wrongly, although nothing turns on it in this case, was not go on to think about the other dimensions of state of mind. But he then turns his attention, and we say with Lord Justice Snowden wrongly, and says, so far as correction of the score of a particular requirement is concerned, it matters little to an aggrieved tenderer why a manifestly erroneous score has been awarded. The important element is that the score was manifestly erroneous. Now we say, well, exactly, of course they'll be aggrieved, but that's not the factor that the Supreme Court has said a judge must turn his mind to. And that is a complete misunderstanding. And also, as I say in the preceding sentence, a failure to engage with the richness of the types of state of mind which could be relevant depending on the facts of the case. So those are the parts of the law that I would seek to draw your attention to specifically in order to provide further ballast for our position. And the essence of our position is the question of whether a breach was sufficiently serious to sound in damages is to be decided upon the basis of the multifactorial test laid down by Lord Clyde. This court should not attempt to narrow it or to gloss it. If this court is to interfere, it needs to find an error in the analysis, and we say you can't find an error in the analysis unless you do try and narrow or gloss the test. In that sense, then there is no reason for this court to interfere with the judge's decision on this issue. We have seen that from time to time, for example, in Ocean Outdoor and on earlier occasions, the application of the test will lead a court to find that the breach is not sufficiently serious. And this is just one of those cases, and it's one with particularly extreme facts. And there's nothing legally aberrant in the conclusion or how it was reached.
Can I just take you back just for a moment to factor 10, which is at tab 10 in Lord Hope's judgment rather than Lord Clyde, because there's be a tendency to read Lord Clyde as a minister. Lord Hope at 550 deals with, you give us to sort of for this 550, 551. He deals with, as he says just at E, 3 factors which emerge from the facts of the factor 10 case which justify the conclusion the breach was sufficiently serious. The first is the subject matter of the breach, and he looks at which particular provisions of the EU treaties were being breached. And he says they're not a case where it could be said that they're obscure or matters of minor importance. And he seems to be therefore looking at what was actually the alleged breach. The second factor, though, this is the interesting point, he does then talk about the second factor relating to the potential of the breach for causing damage to those who are likely to suffer loss as a result of it. So he does seem to be looking not just at the nature of the breach, but its likely consequences. Now, he says it's obvious that if you stop people fishing, then you deprive them of their livelihoods, and that's going to be serious and irremediable loss. How do you translate that into this case? I think Mr Moser says, look, if you conducted your scoring process wrongly, what he actually says is you conducted your scoring process wrongly with the result that we didn't get the contract we should have done. But is that always going to be the case? I mean, how do we, on the assumption that you can look at potential consequences, so Lord Hope says, how does it factor into the approach? Because so Mr Moser says you can look at the result, and that's it. If you don't give the contract to the most economically advantageous tender, then that's the end of it. Is that the end of it?
Lord, no. So in terms of how we understand Lord Hope, I would say that what's critical is the first sentence. It relates to the potential of the breach, so it's a foreseeability question, and it connects, therefore, very neatly with Lord Clyde's factor 2. And of course, it's specific to the factor 10 case. So when they took the decision in factor 10, they'd been warned of the risk, and therefore they knew of the potential for causing damage. So that was something they'd been warned of, and that fits with criterion 2 from Lord Clyde, clarity and precision. Is it obvious that this is going to cause a problem if you do this? Now, if we understand it in that way, and I'd say that's one of the big factual differences between our case and factor 10. In our case, the mistake was looking at the word stair climber and understanding it to be synonymous with stair lift. Now we say that that type of mistake is not one where it's foreseeable that that is going to cause some loss to those who are subject to the project underway.
I mean, it might or it might not.
It might or it might not. It's not like saying we're thinking of making some law. People saying, well, if you do that, you'll be breaching this principle, and all the Spanish fishermen or whatever it is will lose out. That type of mistake. This is people engaged in the granular task of marking, and where they make what we would say was a small error. And that's why it's fact sensitive. In one sense, no one of these factors can be decisive, because the question of whether something is sufficiently serious is, as Lord Clyde said, entirely dependent on the facts and circumstances, and it engages really at a significant level with my Lord Snowden's point about the type of mistake and the difference between being a government body advised that making some legislation or a policy is going to put you in breach of a directive, and being an NHS administrator seeking to understand a bid. And they're different types of activity. Now, if they had undergone some training beforehand, which said, well, stair lifts are like this, stair climbers are like that, this is a really, really important issue in this procurement, watch out for it, because if you get it wrong, you could be in breach of, the stair climber directive of 1988. That might be different, but that's not the type of mistake that was made in this case. So then, turning then to the detail of what we say in response to this part of the appellant's appeal, I'm hoping that I can take it fairly quickly and just remind you that you have our skeleton at tab 5 of the core bundle. And that we go through the specific grounds advanced by my learned friend bit by bit, starting at paragraph 28. But my lords, given what I've said about the shape of the law, I wonder if there's anything in particular you want to ask me about in relation to that part of the skeleton. Otherwise, I would propose to keep moving, because all we do there, although we say it's a valuable task, is work through the judges below's judgment and say why it's right rather than wrong.
You've not dealt, as far as I can recall, with specifically with Miss Moses' point about the last paragraph of Mr Justice Fraser's judgment in the S. What do you say for that?
That is Mr Justice Fraser answering the question that was put to him. While it's true that it appears as a point of principle, it is a point of principle which didn't arise on the facts of his case as found, and therefore we say it can't be determinative of anything. And furthermore, as I've shown the court, there are reasons to be cautious about the accuracy of Mr Justice Fraser's legal analysis. And so if that finding at the conclusion of Energy Solutions is to be relied upon, it must be borne in mind that it rests upon what we say is a legal error.
Thank you.
So the answer to the first point of principle is simply you can't do that. You have to look at everything.
So even if the first two are super weighty,
Yeah.
you can't know what the answer is until you've looked at the others.
So that's the issue for us. And to the extent that Energy Solutions suggests a different result, then you say it's based on the legal error you were just confirming to my lord.
And it's obiter because that wasn't the facts of that case. You know, submissions weren't made to the judge about the things with which we are all concerned.
And then the second point of principle, the bad faith, you've effectively, the battleground for that is Mr. Moses' submission that, well, you look at that and it becomes effectively neutral because it's not a point against you, your clients, but it can't be a point in your favour. And he relies on the bit in Delaney and so on. And you say you have to look at all of it, and the mere fact that it's not deliberate, I think, as you said earlier, isn't an answer.
You know, what Factor 10 is saying, they identified a range of relevant, potentially relevant states of mind. It's not binary between good and bad faith. And the formulation that we see from Mr. Justice Jay early on in Delaney shouldn't be treated as a reduction or dilution of the richer texture that we take from the Supreme Court.
Okay, well, I'll let you take your course. At some point in relation to the ground one, because it arises in relation to the judge's exercise, you'll need to deal with what you say the principle is, which was, I think, your second, when you were outlining your submissions, you said, 2, what is the relevant principle of EU law? I took that to mean the point about most economically advantageous tenderer.
Yes, exactly. Well, that's where I was planning to go
That's
next.
where you
so
go.
that's,
Fine.
that's
Yep.
happy.
Okay.
Yeah, so as the court has divined, we say there is something substantial to say about this. Now, obviously, we submitted to the court below that this identification of the principle is important, and we developed that point in our skeleton. So if you turn within our skeleton to paragraph 34, and then I will build my submissions upon that part of the skeleton. So what we can take from Brasserie du Pêcheur is that the first factor is the clarity and precision of the rule breach. So we say, what rule are we concerned about? The answer that the judge gave was essentially to base himself upon Mr. Justice Fraser in Energy Solutions and his reasoning. And so we have that at tab 22, and within that at paragraphs 54 to 56. And you've already looked at that this morning. In fact, he starts at 53. The broad purpose of the directive and the regulations is to open up the field of public works contracts to fair competition. And in advancing that proposition, Mr. Justice Fraser relied upon a Lord Hope in risk management, which I will take you to for a bit of a closer look in a moment. And then he then translates that at paragraph 54, in essence, to meet. But if we go back to risk management, we would invite this court to find that that's not a full reading of the court in that case. So we've got risk management behind tab 16. So the subject matter of the risk management case was whether a TECL exemption applied to a mutual insurance company created by a consortium of London boroughs. So it was really concerned with quite narrow questions about TECL, and its focus wasn't on the purpose of the directives. However, if you look at internal page 42, and at the bottom of that page, paragraph 10, there's a heading, the Public Contracts Regulations 2006. And then we have the sentence to which my learned friend took you this morning, starting, I think it's 5 lines down, the broad object of the directive, etc., etc. But we say that isn't the ratio decision. We note that there's no EU authority cited, and if you carry on in the report to Lord Roger, who you find at page 63, at paragraph 75, something a little bit different. So what Lord Roger says is, since the whole point is that the directive doesn't apply in the case of such an arrangement because the public authorities are intending to obtain the products or services from their own resources, it's essential that any body which the authorities establish doesn't...
And that's the tackle point.
Yes, that's the tackle point. And then he says, if you turn on...
E.
Oh, it's by E. I can't find it now.
The opening up of
Oh, it's the
understood.
quotation. It's the quotation by F, my lord.
Yeah.
So you see the quotation from the Commission and Germany case.
Yeah.
So which paragraph are you on again?
We're looking at paragraph 75 between E and F. So this proposition is based on EU authority. And then if you carry on to paragraph 92, paragraph 92, you get the following formulation. The 2006 regulations give effect to the directive in English law. In other words, they are the way in which English law secures the free movement of services and the opening up to undistorted competition in relation to contracts which are to be placed by English local authorities. That being the purpose of the regulations, etc.
But that's all being set up surely as a counterweight to the point they actually had to decide was whether the tackle exception applied.
I think, my lord, that is fair, but it's equally true that there has been no case which specifically considers what is the purpose or how do we construe the purpose of the regulations, how do we understand the regulations in the light of a particular directive, other than to say it's got to relate to the particular breach. And that takes us back to the question which we say arises in this case, which has 2 dimensions. One is, what is the perhaps overarching directive which is engaged? And secondly, was the mistake that was made in this particular case between stair climber and stair lift one which did violence to that principle? And we took the court below to Professor Arrowsmith, and you have materials from Professor Arrowsmith in the bundle, and I would invite your attention. It starts at tab 33. Because what Professor Arrowsmith says, if you go back to the European materials, one sees something that isn't so easily reduced to meat as Mr. Justice Fraser suggested should be. So looking at Professor Arrowsmith's work, behind tab 33,
Yeah.
the first paragraph, which I'd invite your attention, is at internal page 164, paragraph 312.
164.
Now I can't. The numbers on the little numbers on the left-hand side, 312. It's you don't have it paginated, do you? So the heading there is the purposes of the coordination directives and their relationship with value for money.
Yeah.
So what she identifies is there's been some uncertainty, confusion over the purposes of the procedural rules. So it's not cut and dried, as Mr Justice Fraser suggests. And then she says...
Well, with respect,
well, yeah.
that's what she
That's what
says,
she thinks,
and
but
she
it-
cites herself.
She also cites quite a lot of other materials.
Well, she, for the confusion point, she cites herself.
Well, she's confused at least. And I suppose she spends quite a lot of time thinking about it. The starting point...
Those two things may be relevant. Okay, yeah, okay.
The starting point is that the directive's main objective is to promote the internal market. And then secondly, it's clear that that's a major means through the directives by which the directives seek to achieve an internal market. And the main focus of their procedural rules is an implementation of transparency to support the prohibitions on discriminatory behaviour that are found in the directives. And then if you turn over to the next page, at the bottom of the page, transparency to support non-discrimination is not, however, the only function of the rules in the coordinating directives. These directives also clearly have the further function of removing specific restrictions on market access. Then on the next page, first full paragraph down, a more debatable question is whether, in addition to the focus discussed above, the positive obligations in the coordination directives also have the further function of promoting a single market by implementing in public markets a process of competition. So competition isn't the be-all or end-all, and this is the sort of invisible hand economic dimension. And so you get at the end of that paragraph, many countries adopt national rules based on competitive procedures to ensure value for money, but from the perspective of the EU, the main purpose of such rules will be to ensure that public bodies choose the best supplier to develop the internal market. And so on her analysis, we are not only worrying about meat. And then
Why is
again,
that binary? That's what I don't understand. You develop the internal market and you make it transparent to ensure that you're not giving the job to your brother-in-law's company. You're instead opening up the market so that there's a fair competition. And you have a fair competition and you give the contract to the Slovakian company that quoted the lowest price. So surely it's all bound up. I don't see it as a binary choice. They wouldn't be opening up the internal market to ensure a higher price.
my lord, no, but the question is, what's the purpose? And the purpose is the promotion of the internal market.
So as to achieve a fair competition and meat.
But meat is only one dimension and possibly a consequence rather than a purpose. So, for example, a core purpose...
But the internal market point doesn't arise here because they're both, one's the incumbent, one's the new company.
Well, my lord, a key purpose, for example, or two key purposes are non-discrimination and transparency. We can, so, you know, the difference between one's brother-in-law and someone from Slovakia, and also how one comes to that arrangement. But they are aspects of opening up the internal market, just as meat might be a consequence, but not a purpose. So what we say the judge in this case got wrong, relying unduly on Mr Justice Fraser apparently, was to elevate meat to be the core principle. And it creates this circular argument because if the principle is meet, and you are the person who doesn't get the tender, then that enables the argument that if you don't get the tender, then that's a breach for which there should be a remedy.
Well, no, because that's a breach that you therefore factor in when you look at the 8 items, if they're all applicable, in factor time. It doesn't follow that just because meet is the right principle, that they therefore get damages, because you've made your submissions for the last 45 minutes as to why that isn't the case.
You're absolutely right, my lord. I think perhaps it's a feature of my learned friend's argument rather than how it's correctly construed. So,
I mean, the point, I was struck, as I so often am, by the questions that my Lord Justice Snowden was asking Mr Moser this morning on the difference, in a sense, between this question of what's the principle being breached and the potential reference to quite high-flown principles, when what we're talking about is a muck-up in a tender process for orthodontic services in East Hampshire. And there's a bit of a disjunct. That's not the fault of factor tame, because factor tame, in one sense, couldn't have been more important in terms of the underlying principle. But we have to be realistic here. Even if the meat principle is important, and speaking for myself, I think it's very important, we shouldn't allow ourselves to become completely unmoored from the reality that whether it's opening up the internal market or meat or whatever it is, that this is a process that, for the reasons explained by the judge, went wrong in one respect.
exactly.
And in one sense, because of the factual difference, factor tame is, in one sense, less help than it might be, because obviously it's a different case. And they're always different cases, because Energy Solutions was, for the Francovich point, a very strong case. I think that would have to be accepted on the facts, because there was not only a muck-up, but the other tenderer should have been disqualified. Okay. Well, I'm thinking out loud, but I do think this question of the elevation of the principle, as my lord put it this morning, is a point.
Lord, I agree. Obviously, we say we succeed however one construes it. Either one accepts that we're in meat territory, or if we say more pragmatically, well, this is someone sitting in a sort of grey and dusty room in East Hampshire picking through the detail of these things. They're not thinking about these more highfalutin things and what really is engaged here, and it isn't like some of the other cases we've seen at Supreme Court otherwise, where a grander decision, if one can put it this way, is being taken, for example, with specific legal advice.
Yeah, thank you.
So that's what I have to say about the relevant principle. I was then going to turn to this question of effective remedy.
Yeah.
My Lord, we would agree with the court that there is a question about the extent to which it needs to be considered, depending on the course or the view that's taken about my learned friend's other points.
Well, I think Mr Moser was clear that even if he was wrong on his other 2 points, they're the points I'm distilling out of all of his grounds, but even if he was wrong on effectively therefore ground 1, he said this would still apply because of the sequence of events in this particular case.
And he raises specifically the procedural mess that has been created by the fact that the stay was lifted, and on the basis that damages were going to be an adequate remedy, and they haven't turned out to be.
Lord, can I then deal with perhaps the factual situation? So when the application was made to lift the standstill, the claimant, as it then was, had the standstill letter. And the mistake which was ultimately found by the judge below was apparent on the face of that letter, but it wasn't pleaded. Nor was there a claim for damages. So none of the parties at that point, nor the judge, had their mind on the stair lift, stair climber point. However, the phraseology that Mr. Justice Bird used, we say, was one which appropriately accommodated all the possibilities, bearing in mind what sufficiently serious requires. So if we turn to his judgment in the supplementary bundle, I think it's behind 5. So within that judgment, internal pagination 1619.
1619. Yeah.
And the way in which the argument was encapsulated is at the end of that paragraph, and it's in the penultimate sentence. If the claimant succeeds, it would be compensated in damages. Now, and then that phrase, if the claimant succeeds, I think appears again elsewhere, but we say that it's important because it encapsulates within it necessarily success on sufficiently serious.
Well, in fact, the judgment slightly conflated the 2 points, because the standstill means that you can succeed on getting the contract, even if it isn't sufficiently serious. Because suppose the standstill had stayed in place, they, at the end of the day, well, in fact, you've won. It wasn't sufficiently serious, you were never going to get any damages. But as you've won, you ought to get the contract. And then they talk about success also in terms of damages, albeit, as you rightly point out, without anyone particularly concentrating.
But it remains the case that to succeed, one must succeed in relation to sufficiently serious. And it can't be the case.
Not when you're discharging the injunction, because to succeed, in the normal procurement case where you've got the standstill, to succeed just means winning in the sense of showing that you should have got the bid. That's why I say it slightly conflates the 2 points of success.
Well, there are 2 different types of success, I suppose.
Absolutely.
But of course, the point is that if one is comparing those 2 different types of success, it is nevertheless inescapably the case that success in the damages sense involves success in relation to Francovich.
Yeah, agreed, and all Mr Moser is pointing out, and he's perfectly entitled to point it out, how far it takes him is a different point. But the fact that if they'd have had the standstill and the result of the trial had been as it was, they would then have been awarded the contract. So in fact, they should have still had the benefit of the standstill, because damages turn out to be an inadequate remedy because they didn't succeed in showing it was sufficiently serious.
But to make the apparent contradictions work, it's certainly right to adopt the analysis, however facile, that my learned friend showed you from the European Court this morning, which is and one which is not foreign to this jurisdiction either, which is there's a different test at a different time. And it's not necessarily going to be the case that it's problematic. And of course, it is the uncertainty insofar as that there is uncertainty as to whether one might succeed in relation to whether a breach is sufficiently serious can be part of the evaluative exercise carried out by the parties and the judge at that stage. Now, certainly before Brace Yourself, as well as afterwards, parties have chosen to ensure themselves, depending on which perspective you take it, as to sufficiently serious by agreeing not to take that point. But that's not something which the genesis of which is this judgment. It's been acknowledged as a necessary feature, and one can see that in some cases one can anticipate that it might be more of an issue than others, and therefore it's more likely and more able to be accommodated. But
well, it plainly didn't arise out of this case because Mr. Justice Fraser, doubtless fresh from his triumph in energy solutions, raised it in, is it East Lancashire Health? In the second volume of Authorities, which was a set-aside case. And he said, tab 24, Lancashire Care, which is 2018, he said, the point wasn't fully argued. I think he raised it. Both parties agreed that at an interlocutory stage, the court couldn't come to a decision on the question of whether the alleged breaches were or could be classified as sufficiently serious. Both parties agreed the point should be taken into account when considering the question of adequacy of damages as presenting an additional requirement which any claimant had to satisfy to recover damages at all. That is therefore the approach by agreement in this case which I adopt. So the point is out there and has been, if not since Energy Solutions, then certainly on an automatic suspension dispute since Lancashire Care in early 2018.
well, Lord, yes, and I suppose if the claimant had managed to identify the stair lift stair climber point in its pleadings, it would then also have been possible for the defendant to say, well, okay, we see your point about stair lift stair climber, but that's never going to be sufficiently serious. And everyone could have proceeded on a more informed basis and people could have made their elections accordingly. But the fact is it wasn't pleaded and it couldn't have been analysed and accounted for on each side or by the judge in that way. But that doesn't mean that by reason of the standstill or the being lifted, that there is something invidious in there being a subsequent finding not sufficiently serious, because one cannot remove what is a requirement per Lord Mance in Energy Solutions by a decision which is made at an interim stage.
Isn't whenever you get a suspension dispute, isn't it invariably the allegation made by the claimant, the disappointed bidder, that if the mistakes hadn't have been made, they would have got the contract?
That's certainly typical.
Well, I'm just struggling to understand
Why else would they?
Why else would they be trying to maintain the suspension?
Yes.
Well, I mean, as a matter of reality, there are some claims where people say it's gone so horribly wrong, no one's got the plaintiff's idea of who would have won, and therefore we're entitled to have it rerun properly. And there is a principled public interest in ensuring that. And that's not saying I would have won. If they get to damages, it might have said I had a 30% chance of winning, etc.
But so if we put aside just everything's gone wrong, you know, we just don't know, it's just a shambles, just a mess in here, the whole thing needs to be run again. The ones that, in the case where somebody's saying, no, I wouldn't want, because of the meat principle has not been adhered to. I mean, one advantage of Mr Moses' approach and Mr Justice Fraser's approach is that it will inevitably result in somebody saying damages is an adequate remedy, because it will follow as night follows day, that if you didn't grant it to the most economic advantageous tenderer, damages will follow. Therefore, from the authority's point of view, or from the authority's point of view, they should be able to go ahead and back their judgment and award the contract to the new successful bidder. Why isn't that a good thing?
Because each set of facts and each piece of litigation is different, and the practice that existed both before and after, namely for the parties to reach an agreement between themselves as to the approach that's going to be taken to sufficiently serious, is one which accommodates the variety of situations. Now, Mr Moses says, oh, that's uncertain. Of course, I would say, well, that's flexible. And that's meeting the needs of parties in this type of litigation. I think, as Mr Moser fairly observed, I mean, it's only a very few of these cases that actually reach the court. And so, while, again, as Lord Hope observed, there's something novel about this, and it's the question of sufficiently serious introduces a set of factors in decision making which weren't previously there. The fact is that they are there, and the fact is that they can be accommodated, and needing to accommodate the uncertainties of litigation at an interim stage is not wholly novel. It's inherent in every interim hearing, you know, if one looks at it on an American cyanamide basis, that there will need to be catering and balancing of the various possibilities. But certainly what we would say is that if you're a claimant who doesn't plead a point, then it's got to inhibit you from praying it in aid at a later stage, you know, where neither the breach nor the damages were pleaded at the stage that Mr Justice Bird was looking at it. And it seems to me that there is then a further unfairness in this case. May I turn my back in relation to this? Because obviously I think it merits the description repercussive, which is used in the NHS. So just to reiterate, my lords, a defendant can essentially look at it from the perspective, well, what's more important to us? Not giving the contract, or is it more important to preserve our position in relation to sufficiently serious? And that's what gets reflected in submissions and or in arrangements to give undertakings in relation to that.
I mean, here, of course, there could have been a point that would have arisen, or could have arisen, if there'd been an undertaking. It then might have depended on the word of the undertaking, because the words of the undertaking might have clearly related to the matters as pleaded at the time that the undertakings were given. So I could foresee a whole raft of further complications arising out of that. And I'm not enthusiastic about any indication that requires people to plead the kitchen sink just on the sake of for the out of caution, as it were. The better point perhaps for you is not the pleading point necessarily, but the point that if this had not been an interim measure, and if everything had been decided then and there by Judge Bird, this claim would never have arisen because it wasn't pleaded. So if Judge Bird had said on that doubtless Friday, well, actually, I've got all next week because I'm down from Manchester, my case is settled, so I'll hear this case and determine these points starting Monday, this point wouldn't have arisen on the facts of this case.
That's exactly right.
Can I just ask you one point on damages being an adequate remedy? I mean, is it the case that in English law it will always be damages if you're an unsuccessful tenderer who should have won, will always be awarded on a sort of expectation basis, i.e. loss of profit, rather than just a wasted expenditure?
My Lord, we were all very interested to hear what my Lord said this morning, and my Lord's words fell on somewhat uneducated ears. Certainly, we're interested in the thought that damages might be
Well, there are different
conceived of in that
approaches
different
taken by
way.
different
Yes.
European countries to these problems. But I mean, one problem for the tendering authority is, of course, that you end up with lots of potential claims for damages from anyone who's bid. On the other hand, from the bidder's point of view, they are perfectly entitled to say, well, you know, I did waste a lot of time, money and effort on this process and you've messed it up. And I'm at least entitled to have that back if you can prove it.
Well, my Lord, we can see how that perhaps fits more closely with the reality of the situation. I think, again, if one looks at the types of cases which we have in the bundle, there are some which are of such sort of magnitude in terms of the scope of provision. So if one looks at a contract for something being provided nationally, where you're either the provider or you're not, that is a case which is different from this case where your practice happens to be located in a particular area and there's nothing to inhibit you from offering your services to people in the adjacent area, for example. And again, it seems to us that that may be a dimension which becomes relevant to damages as well.
Well, yes, I mean, damages don't arise, but just so that you've got fair disclosure of it, I picked all this up from the European Procedure and Public Partnership, Private Partnership Law, EPPL, for 2019, talking about the approach in French law, which is where you just go straight from a breach into damages, but they never seem to get what we would consider substantive damages. They tends to be restricted to wasted expenditure. But inevitably, if you're talking about a civil law code, it's difficult to pick up some of the reasoning.
The thing that provided us with some analogy was the way that things operate in public law in this country, where the court may find that there's been an error of law or a breach, but then there will be another stage about how that needs to be, how that needs to sound in remedy. And insofar as one could have damages in a public law claim, which is increasingly the case, there might be a reason why you don't have damages. And it seemed to us that that was a better reflection of the position in procurement law, which sort of exists with a kind of Venn diagram with these this intersection between these two realms. But that's why we say it would be a mistake to look at it as a purely private law set of determinations, because it doesn't capture exactly what, as I showed you at the beginning, the Brasserie de Pêcheurs and so on was saying we were engaged in. But this working through of what it might mean for damages, we say, is not necessary to be done in order for this court to be able to give a judgment in this case.
Anything else on the effective remedy point? I mean, we've got your submissions. I mean, I think one of the other points you make in your submissions is that the effective remedy is not, as it were, a promise that you're entitled to a remedy in every case.
That's exactly what the effective remedy requirement is for a remedial process. It doesn't give you a guarantee of damages in your case. And we say that what the regulations do is provide for that process. And it's unnecessary to guarantee damages in any particular case or any amount of damages. Then I would turn to our attack on the liability judgment. Of course, my Lord, if we are successful in defending in relation to sufficiently serious, then it won't be necessary to go this far. And as I indicated at the beginning, I also propose to add into this part our point on rescoring, which arose as an additional reason in relation to the first appeal. Now we deal with this in our skeleton at paragraph 63, and we say that the errors made by the judge on the liability judgment are ones which reach the threshold, however one puts it, for the making of an appeal. They're not mere matters of weight. So if you have open the judgment, which is in the supplementary bundle behind tab 11, and then within that, if you just start please at paragraph 42, if I can just show you the key parts. This is page 200. Under the heading, the evidence general observations, third line down, I found each of the defendant's 9 witnesses to be honest and genuine. Each of them sought to do their best to assist the court. And then at the top of the page, I was generally impressed by the careful way in which the evaluators had tried to carry out their functions. And then if you turn on please to 130. So what's said at 130 is that the bid said that the stair climber will be used to support wheelchair users being safely transported up and down stairs at the practice. And then the criticism that was made by the judge of the approach to the defendant there was if the defendant was in any doubt about the nature of the proposed solution, it would have taken a matter of moments to establish that the claimant was not proposing a fixed stair lift, but was instead providing a stair climber. And there you've got the two acceptances which my learned friend took you to this morning. And if you go on, please, to 134, then at the bottom of the first page containing 134, and then, sorry, over onto the next page.
Just out of interest, what's a stair riser?
So a stair riser resembles quite closely that which is used by the ambulance service to get people in and out of buildings. And I think we've described it as a kind of mobile sack. So whereas a stair lift is something presumably you might well have come across where someone sits on something and then that mechanism goes up and down the stairs. A stair riser involves someone effectively being hauled up in the contraption.
Is a stair riser the same as a stair climber? Because there the reference to stair riser, which my lord raised with you.
Oh, I'm sorry.
The bid document said stair climber.
Yeah, that's what I'm getting at.
Oh, sorry. Yeah, I've got sort of conceptual blindness at this point. I'm not sure that we have expressly dealt with that in our skeleton.
Is it just a typo for stair climber?
It may be a typo, my lord. That's what
Because, well, she's certainly referring it to, because she noted the promised installation of a stair riser, whereas in fact it was the promised installation of a stair climber.
Quotation for a stair climber. It's probably just, he's probably dictated it. It's a stair, it's climber, riser. It's, yeah, okay. So we're only dealing with two things here.
As far as I'm aware, certainly it's the difference between a sort of fixed mechanism with a seat in it, which I think we're all familiar with,
Yep.
And perhaps something many of us will be less familiar with, which is the stair climber, which is the item which was to be used, proposed by my learned friends. I'm sorry, now I'm feeling really confused. Climber, yes.
Yeah.
So then we have the key point at the end of this paragraph, which is the proposal is to install a stair lift, which is not really adequate, as this is not only about wheelchair users, so I just ask you to remember what was in the bid, but people with reduced mobility and pram access, and therefore needs to be easy to use. And bear in mind here that the contract is forbidden for the provision of orthodontic treatment, which is something typically for teenagers. And then if you go on to 136, and then what happened at the moderation, the CH agree with Olivia's comments around limited accessibility for patients/carers with limited mobility needs. So again, what's bearing on the minds of the evaluators expressly and recorded at the time is this is focused on wheelchair users. It's not thinking about the kind of people which we anticipate having access problems in this setting. And then again at 139, at the bottom of the page, the judge notes the evaluator's evidence. A child on crutches wouldn't be helped by either mode, although she accepted that a person with a broken leg may be able to use a climber. And then what the judge says is, doing the best I can on the evidence provided, I conclude that a stair climber could be used by a patient with limited mobility who was not in a wheelchair. But he doesn't there think about prams. He then goes on in the next paragraph and he says the evaluator made a separate point about parents with buggies and prams. So he says that's a separate point. And then he says, was also not specifically mentioned in the contemporaneous documents. But if you go back to what we looked at a moment or two ago,
134. Yeah.
it was in the documents. And then he says it may have been an afterthought, but same point. And we don't even need to go back to the original documents to make this point, because it's clear that we say there's an error on the face of the judgment. And then he says, I accept first floor premises will create a difficulty for them, but that's caused by this instance of the stairs and isn't limited to parents with disabled children. And then he says, and this we say is another problem, the principal focus on access under the Equality Act is on the patient, not the able-bodied parent with a pram or buggy. But you will have taken from our skeleton that, of course, the Equality Act is not only focused on disabled access. You're going to be thinking about characteristics such as sex and maternity, and the brutal reality that it's going to be mothers with buggies who are taking their children to orthodontic appointments. Then if you go on to 141, internal spreadsheet recording the overall conclusion, and then you've got the point at the end of that, which is recognising that patients with impaired mobility isn't limited to those in a wheelchair. And what the judge concludes at 143, it follows from what I've said that this reasoning was flawed, based as it was on two misunderstandings. So, of course, what we say is that, yes, it's true that there was a misunderstanding between stair lift and stair climber, but that difference isn't the material difference, because the worry is about access across the board, a key part of which is access for families, which is a real issue when you're providing orthodontic treatment, and that is what makes things seem not good enough in the minds of these NHS evaluators, not a sort of particular concern about the way in which one will be.
Well, you have to be careful not to overstate it.
I'm sorry.
I mean, we have to be careful not to island hop. We have your point about what was said in 134. We didn't hear the witnesses. We didn't see what they said.
But what we do have, though, is the judge's note of what he took from them. And if you go on to 146, please, my lord, then a few lines down, he says, the defendant sought to rely on evidence from its witnesses that, had it known the claimant was proposing a stair climber, it would have made no difference. And then he then says at the end of this, I prefer to have regard to the written records from which it's possible to draw conclusions as to whether the claimant's score could or even would have been higher had the content of the bid been properly understood. But as I said a moment ago, if the judge had been looking at the written records, which he himself recorded, then he wouldn't have got to the position that he had. And then if you look then at 147, he then links the mistake about the stair climber, stair lift with the difference in the score. And we say, if you look at the material that the judge sets out and has taken from the documents, it's not the stair lift to stair climber which leads to the difference in the score. What leads to the difference in the score is not addressing the variety of types of access for the people who are likely to have access problems.
Can I just ask you one question? The Equality Act, I mean, a protected characteristic under the Equality Act is age, isn't it?
Yes. So I think we said age, sex, maternity. These are all features which would arise. Now, it may well be that some of these difficulties arose for the judge because, of course, the stair lift, stair climber point was one which only arose at the hearing, and so neither party was in a position to have dealt with it in pleadings or skeleton arguments. It was something that appeared to arise organically, and perhaps that's what allowed the judge to make these errors, particularly bearing in mind that there were 30 other criticisms which he had to address. But going back then to our skeleton argument and how we put this.
Just before we leave the judgment, Mr Moser also pointed out another error which the judge identified in relation to the premises. Was what Mr Moser said about that right?
Yes, but what the judge says is that wasn't significant error. He says it's the stair climber, stair lift point, which is the significant one.
I think Mr Moser said that they'd marked down because the other premises weren't adequate and they were only going to be used if there was a flood.
But if you look at that which the judge quotes in his judgment, one doesn't see that as being operative as far as he understands it.
Thank you. Sorry to interrupt.
No, that's quite all right. I'm just aware of my time limit.
I'd have said you were well on course.
Oh. So if you return to our skeleton, which is perhaps the most convenient way of taking this, and it may be that there's very little to say, having taken you through the judgment.
Well, I think you've dealt with the point from 63 to 67, haven't you? Because that's looking at the passages you've just shown us.
I'll just have a look at my note. I think that's probably right. And then, yes, if you have within our skeleton at paragraph 70, I think I probably made that point orally too as well, which is that it's where the judge says, well, this wasn't mentioned in the documents, it may have been an afterthought, whereas we can see that he himself quotes from those documents, and so that's just a straightforward mistake.
When you say legally significant error, what do you mean? That this was an error but it had no effect? Or should have been found to have had no effect?
Oh, in our ground 1A.
Well, your ground 1A and your ground 1B, it's your repeated phrase, not a legally significant error. I'm just trying to unpick that. What does that mean for these purposes?
Yes, it's a mistake, but because he misunderstands the significance of the mistake in the defendant's decision-making, he gives it significance, which is erroneous. So yes, we make a mistake about stair lift, stair climber, but that isn't the reason why the defendant is concerned about fulfilment of the access criterion. And you can see that the reason why the defendant was concerned about the access criterion from the contemporaneous materials, even though the judge quotes them and says, oh, well, that's not apparent there.
So, I mean, effectively, what you're saying is that the judgment itself is internally inconsistent.
Yes. So it's not a case where we're saying, oh, let's go back and see what the witness has said. I mean, the curiosity is that the judge himself says, this is what the documents say, but he himself doesn't appear to understand how the mistake interacts with the reasoning. So the mistake that they make about the stair lift, stair climber is not causative of the decision they make on the mark. And perhaps to go back further, it's because access itself is this broad concept. Access isn't, as the claimant appeared to construe it, only about people in a wheelchair. Again, if you go back to, I think you looked at CSDO2 right at the beginning of the day, what bidders are being asked to address is access in all its conceivable manifestations, not just can a person in a wheelchair get up and down these stairs. And you can see why access for people with prams or with a range of difficulties is so material in the circumstances of an orthodontic contract. The other error that we identify in our skeleton at paragraph 74, and I've shown you it, is this declining on the part of the judge to have regard to the evidence that he was given about whether it would have made a difference or not.
Yeah, well, I think you made that submission, haven't you?
Yes. So then the only thing that remains for me to address you upon is the rescoring point, which is this, what we say is an additional reason to uphold, and it's dealt with in our skeleton at paragraph 34.
Paragraph
34.
Thank you.
Sorry, 36. So, what the judge, having said that there was a manifest error, decided himself to rescore. And he rescored, telling himself that it was the stair lift, stair climber question which led to the difference between a 4 and a 3. Now we say, first of all, well, query, is it right to go on and rescore? But if you do, as a judge, go on to rescore, you have got to look at the totality of the evidence in relation to the question you're rescoring. So this wasn't a question about, do you have wheelchair access? This was a question about access to be broadly construed. And in fact, if you, for example, go back to the bid, it's over several pages addressing access and all its many possibilities. And then what the judge did was say, well, you made a mistake in relation to climb a lift. I find that mistake is what makes the difference between a 4 and a 3. Because that was a mistake, I find that you would have given it the other number if you hadn't made that mistake. But we say that's elevating this one sort of micro element of CSDO2 in a way that was wrong. And what the judge ought to have done is say, well, I'm not in the position of an NHS evaluator with all the sort of hinterland that they have, and therefore I can't rescore. and it would have become a loss of a chance case. Or I suppose he could have sent it back to rescore, but that doesn't sound very realistic. But it's certainly what he did do was not the correct approach in saying, well, you made this one mistake, and this one mistake in this richly textured question is what makes the difference between a 4 and a 3.
But that's the second point of the two you articulated, and that's parasitic upon the arguments you've just made about whether the judge was right just to focus on this or whether there was the wider access point. I thought there was some wider point here you had about that he should not have rescored at all in any event.
Well, we say if he was going to rescore, he had to do so looking at all the evidence. But what he did was, for example, exclude from his consideration evidence that he did have from another witness about the relative merits of stair lifts and stair climbers. And so he said, well, I'm not going to take that into account because I heard that evidence in relation to another of the questions under the bid. So we say, if you are going to rescore as a judge, then you need to look at everything. So, for example, you've got this multi-page bid on this particular question.
Where is it, which judgment is it that you say shows he didn't have regard to everything?
In the first judgment.
Yeah, the liability judgment.
Sorry, I need to go back to it.
Yeah.
He says, I am going to rescore and I am not going to look at this other material. It'd be easier to take it from the skeleton. It's 147 of 5229.
He refers to didn't take evidence into account in relation to MPO2.
Yes, so that's the other witness that he notes, explains to him, it's at 132, my lord.
Yeah.
So a witness explains to him that a stair climber is not a great idea. And he says, I'm not going to take that into account when I'm making a decision about CSDO2, which
So
will
what
make...
was that? It's an expert evidence, was it?
It's an evaluator's evidence.
Yes, but not somebody who was involved in this evaluation.
She was involved in another element, MPO2.
But fine, but so not involved in this, the evaluation of CSDO2.
No. But
So I've said repeatedly that this is the trouble with these cases. That's opinion evidence for CSDO2.
absolutely correct. But the difficulty is that the judge goes on to rescore, and I think...
But a judge is, in a scoring case, in a scoring challenge, you would expect a judge to rescore if it was justified on the material. I understand you say it wasn't justified on the material, and I've got all those points, but the judge would be failing in his duty, wouldn't he, if or she, if they got to the end of, this is now the this is the second detailed fight between these parties, and he declines to rescore. There's got to be a good reason. He looks at all the evidence and he says, no, I can rescore this because it's a straightforward point.
Well, Lord, I think it's the first detailed fight because it's the liability judgment, but in any event, but he...
No, because we've got one detailed reported judgment on the lifting of the stay. So then it's round 2 liability and then round 3 Francovich. So this is the second round. It's a scoring exercise. There's a vast variety of points put in issue, all of which the judge rejects except this one. He identifies this. He has all that evidence in mind and he thinks, well, I can rescore it.
But he explicitly excludes for consideration, having made the stair lift, stair climber point the determinative one, the evidence he had about the relevant benefits or disadvantages of a stair lift and a stair climber from an NHS evaluator.
Yes.
Sorry, I mean, is that actually what he's done? I mean, just to try and put this into context, if we go back to paragraph 120, that sets out CSD02, and there are lots of things that it deals with, and you've made the point that accessibility of premises is only one of the things that contributes to the score. But the way the judge does it is to say, at the end of paragraph 147, look, the 3 evaluators met. 2 of them said it's a 4. The third one was Miss Falrock-Jones, was the only one who said no, it's a 3. And the only reason she gave for differing from the other 2 was because of the accessibility question. Ergo, if she was wrong on that, I mean, also, ergo, all 3 of them were satisfied on all the other things that it would be a 4. Because Mrs. Farrow didn't say, well, it's accessibility and car parking and. So why isn't the judge rationally entitled to say, well, since nobody had spotted anything else wrong with the score on the compliance with the CSD02 factors, it's got to be a 4, because that's the only problem that anybody's identified. You know, that in other words, the evaluators themselves they've looked at all the other things, and 2 of them say 4, and the only reason that Ms. Farrock-Jones says it's a 3 is the one thing he says that she was wrong on. Isn't that rational? Isn't he entitled to do that?
Well, Lord, it's difficult to say that it's inherently irrational, and perhaps that forces me back to this original position, which is where what the judge has identified as the flaw in the reasoning is not correctly identified, then he necessarily didn't understand what led to the 4-3 difference. So what we can see on the face of his own judgment is that what led to the 4-3 difference was an issue about access for people with buggies, etc., more widely construed. The judge has told himself that what led to the difference is whether it's a stair lift or a stair climber. Therefore we say, even if my lord is right, and one cannot say that it's inherently problematic to rescore, albeit that the judge doesn't have the sort of hinterland of a particular set of evaluators. The difficulty for him is that he then made his own decision on how it should be rescored based on a flawed understanding of what went wrong, and therefore that would contaminate his, should it be a 4 or a 3?
Well, that's why I went back to saying, to try and isolate this point out, because you've really come back to the previous point.
Exactly.
I mean, very elegantly, I'm not suggesting otherwise, but you have come back to the previous point rather than it being a separate and standalone point of principle, which I'm bound to say is how I had read it, or at least I thought I'd understood it. Okay, is there anything else, James?
May I just turn my
Of course, please do.
Thank you very much, no, my lord.
No, thank you very much, Miss Morris. Mr. Moser, do you want to start with anything you've got to say on the stair climber, stair lift excitements?
Well, the first thing I want to say about the stair climber, stair lift excitement is that this court ought never to reach the point at which it has to address it, because of all the points that we have made in our skeleton argument, paragraph 65 and following, about the nature of the review on appeal in this court. This is not a court where it is open to the court or desirable that the court should revisit the factual findings below which the learned judge reached with the benefit of all of the witness evidence that he heard.
All right, well, we have that point.
So
What
for-
about if we decided to look at it or interfere with it or consider it again?
If quod no, the court felt inclined to go there, I respectfully disagree with my learned friend about what was the evidence below and also how the judge read it. If we look at page 225 of the supplementary bundle, we see the record of the moderation meeting, which led to the moderated score of 3, and the comments attributed to the evaluators. And I've read them before, I'll read them again. First, this is evaluator Ms. Farrak-Jones. Due to the need to use alternative practice for patients who are unable to use the stair riser, it is felt these patients will be disadvantaged as equipment will not be of the same standard. It's not the case that it's only the issue of the stair climber. It's always both misunderstandings. The misunderstanding about the premises, completely misunderstood in 2 ways. The first, that they were being offered for this purpose, which they weren't, and the second, that they were somehow inadequate for accessibility, which was of course irrelevant because that's not the purpose for which they were being offered. That is what led to her being happy with score 3. The second evaluator, VE, having talked through the access limitation and the lack of information around the facilities available at the alternative site, score moved down to 3. So again, the alternative site is important here. And then evaluator 3 agree with Ms. Farrak-Jones' comments around limited accessibility for patients' carers with limited mobility needs. Following discussion and reasoning, provided score downgraded to a 3. Now, we don't know from this what the discussion was. That will have been the subject matter of the line evidence when these evaluators gave their evidence. And then I've already explained, or rather pointed out in opening, that the witness accepted that she hadn't understood the difference between a stair lift and a stair climber. Indeed, she introduced a third concept that isn't the case at all. A stair climber is one that would, for instance, allow you to get a wheelchair user up the stairs, and who knows what a stair riser can or can't do. She has said that her views about the inadequacy of stair lifts were informed by an earlier evaluation on an unrelated matter, which perhaps one hazards where stair riser came from. But you have both of those things, and we see at 139 what the judge says if the further evidence was on this point. And about halfway down the paragraph 139, when asked if a stair climber could be used by non-wheelchair users, no dispute it could be used by wheelchair users, Mr. Spathula said, "I think so. I'm not aware of any reason why not." That evidence was not challenged in terms. On the other hand, Ms. Farrak-Jones said in evidence that having now been made aware of the difference between a stair lift and a stair climber, a child on crutches would not be helped by either mode. In the end, though, she accepted a person with a broken leg may be able to use a stair climber. And then we had that bit that I took you to, doing the best that I can on the evidence provided. I conclude that a stair climber could be used by a patient with limited mobility who was not in a wheelchair. It follows the criticisms made of the claimant's bid were misplaced. And clearly we see why we shouldn't be troubling this court with these sorts of evidential matters.
We all well understand that point, but just to deal with, can you just confront the point that was made at the end of paragraph 134? Is the real problem with this is that it doesn't help people with reduced mobility and pram access, and the judge doesn't seem to have dealt with that.
Well,
and indeed says that pram access is an afterthought when it plainly isn't.
The judge at 140 says he thinks it may have been an afterthought. well, the judge might be criticised, albeit lightly, for that. However, he accepts first floor premises could create such a difficulty fairly, but puts it into context and says that, well, that's caused by the existence of stairs. And when he talks about the Equality Act, he doesn't say that it doesn't apply to all of the protected characteristics. He merely gives more weight to the focus, what he calls the principal focus, not the only focus, of the Act on the patient, no doubt in the context of this procurement as well, which is where plainly the access of patients is going to be the principal focus. So it's not that the judge has made some egregious error in relation to parents with buggies. He's looked at it, he's taken it into account. One might have a quibble about him saying it may have been an afterthought. That still means it may not have been an afterthought. And no doubt that's some reflection of what he heard in evidence. But it doesn't come anywhere near the threshold of saying that he made an obvious error in his assessment. In particular, when he then at 147 in my submission very fairly draws together all of the strands. And that follows on from 146, of course, where whatever he heard in evidence, he particularly on the accessibility point says that he preferred the written records from which it was possible to draw conclusions. Well, we haven't got it, but there's the well-known judgment in Gestmin, or Guestmin as it's sometimes pronounced, of Mr. Justice Leggett, as he then was, where he explains the problems with witness recollection and evidence, and why written contemporaneous evidence is often to be preferred. But that's what the judge has done. And he then says, he focuses on all the issues, and he says halfway down by the second whole part, having regard to the totality of the evidence, I am satisfied that the overall score has been different to the one given. And if I may say so, I'll gratefully adopt the comments by my Lord Justice Snowden, that if you read the transcript there, it's perfectly plain what happened. The other two were completely satisfied about all the aspects. They were a 4, and they brought it down to a 3 only because of the first witnesses' criticisms, which found upon 2 errors. The first admitted, including by the defendant. The second found by the judge in a way that can't be faulted. And over the page of 230, at the end of 148, the judge says the defendant simply misunderstood the basis of the claimant's bid in 2 connected respects, not just in 1, in 2 connected respects, and therefore took into account matters which it ought not to have taken into account. Of the 2, the point about the stair climb was obviously the more significant. I'd say in brackets, but not the only one. On the evidence, I'm satisfied that had the defendant understood the basis for the bid, the outcome would have been different, even allowing for the margin of appreciation. So I say not only that we shouldn't be engaged on this exercise, but if one engages with the exercise, there is really nothing except the mildest criticism that could be made of any aspect of the judge's reasoning here. Certainly nothing that reaches the threshold for this court to replace its own view of the evidence for that of the judge below.
And do you have the same answer to the rescoring point?
I have the same answer to the rescoring point as my principal point, which is the 4 versus 3 rescore is perfectly obvious from paragraph 136 and the reasoning in paragraph 147. And also that is, as a matter of law, the appropriate approach, as we've pointed out at paragraph 77 of our skeleton argument, where what the judge has to do, according to Woods Building Services and Milton Keynes and your lordship, Coulson J, as you then were, what he has to do, citing Letting International and Silver J, is not to embark on a remarking exercise and substitute his own view, but to ascertain if there is a manifest error which is not established merely because on mature reflection a different mark might have been awarded. The issue for me is to determine if the combination of manifest errors made by Newman in marking the tenders would have led to a different result. Well, we know what the manifest error was here. If you take it away, it leads to a fall. So that is, it's correct both as a matter of common sense and as a matter of law.
Can I just ask you, I've been focusing on the stair lift, stair climber point, but just on the alternative practice, as I understand the point, Ms Farrow-Jones thought that the proposal was that if you can't use whatever the thing is to get you to the first floor, you go to an alternative venue.
Yes.
And her point was that the standard of the equipment at the alternative venue isn't as good.
Yes.
So she's saying that if you can't use whatever it is to get you up to the first floor at venue A, you've got to go to somewhere where it's just not such good equipment. But in fact, the true position is that I understand it, your clients were never intending to send people who couldn't get up the stairs to an alternative venue at all.
That's correct.
So why is that better? Because they're just not going to get treated, full stop.
Well, no, because the finding of the
Well,
court
not by
is-
your clients.
the finding of the court is, as my clients submitted in their tender, that they would get people up the stairs.
No, but if they couldn't get up the stairs, because the premise of okay, so in which case the alternative premises really doesn't feature at all then, is
No,
that right?
not at all. It's a complete irrelevance. It was taking into account in public law terms an irrelevant consideration. The alternative premises featured elsewhere in the bid.
Yeah,
It was to do with if there was some catastrophic event, like a flood.
yeah, no, I understand.
And the other bidder had as its solution for accessibility alternative venue. So perhaps some confusion crept in that way, but it was not relevant to my client's
So your clients,
answer.
your answer was, it's not that we won't treat them, it's just that we will get, by hook or by crook, in some way, shape or form, just right, we'll get people up the stairs.
Absolutely. One hazards that must have been what's been going on. They were the incumbent bidder. I mean, that was my client's evidence. Obviously, your lordship hasn't heard the evidence. So that's what I say on rescoring, my lords. If I may, on any other questions before I move back? Or
No, it's just a question of whether there's yes, I suppose the question is there anything in reply to Miss Morris on the substantive appeal?
Yes, as briefly as I can. I have to go back to the beginning and Lord Clyde and Factor Tame and the question of the principle that is being breached, because my learned friend, perhaps taking up the suggestion, the interesting line of questioning from my Lord Justice Snowden this morning, expanded.
That would be a yes, Prime Minister type of interesting,
But
a bold suggestion, Minister.
your lordship may say that, but I couldn't possibly comment. Perhaps building on that, my learned friend went further than I discerned in her skeleton argument on the question of principle and the importance. And I followed the line that your lordship is taking.
Well, I'm sorry, I was just to be clear, I just been putting a point.
Yeah,
you know, as
I
a-
understand. In my respectful submission, it proves too much, and therefore it can't be the right way of looking at that. In order to get into the Francovich arena, you have to ask yourself, what is the principle of EU law that's been breached? And then you ask, how important is it? Well, the principle of law that's been breached, as you know, ad nauseum, in my submission, is meat. And that's because that's the direct consequence of the mistake and the failure to identify the correct meat tenderer. Now, if one says, no, one has to become more granular, and it's actually the actual administrative error itself we're looking at. We are, in fact, in a world where my learned friend is inviting the court to say that no principle has been breached at all. My learned friend quite rightly says there is no stair climber directive, EU 2004/66. And that cannot be right. Underlying every Francovich damages case is some sort of error. Then you identify what the principle of EU law is that was breached as a consequence.
The point is, I mean, I think it was put, Lord Justice Coulson put it to you, raised it. Factor tame was a government action. It was legislation passed to keep certain people from fishing in certain waters.
Sure.
And so at that level of decision making, the breach necessarily engages very lofty principles, which I think is essentially what was said in the case. You know, that it's important because they're big principles. I think the disconnect is that we're not here dealing with a legislative act or a governmental act, dealing with such lofty principles. We're dealing with, as my Lord put it, I think, I can't remember who put it to, but we're dealing with people scoring particular items on a sheet. In a process, in a dusty office, I think was the expression used, or whatever. Is it right that simply by saying, well, the whole ethos of any procurement process is meat, ergo meat is important, ergo every error that leads to a difference in a procurement process will lead to damages? I mean, because that seems to be what you're saying effectively, and
damages where
and Justice Fraser seems to have said pretty much the same thing in those terms.
well, it's 100% that there would have been an award. Well, the difficulty is that the Supreme Court has taken the state liability principle and has grafted it onto public procurement law. In public procurement law, you will very often have a scoring challenge. My Lord Justice Coulson is right in saying, well, in energy solutions, the magnitude of the errors was just so much greater. But in essence, my Lord, they were the same sort of errors. You had individual scorers sitting hunched over their chits in energy solutions, getting stuff wrong. And if we look at unseen, I think, at the moment, Consultant Connect, which is the only other one that we have available, that's in Authorities Bundle 2, tab 32. That's also a rather parochial sort of thing. What had happened there?
It may be parochial, but it was deliberate manipulation. Just the sort of thing that the public contract regulations were designed to get rid of. I mean, you're edging towards a Coulson Clay Cross councillors scenario, fiddling it to get the right result.
Well, it was found that those who did it probably believed naively that their conduct was not unlawful. So that saves them.
I'm sure that that was the defence in the late 70s too.
There was a scoring exercise. I'm reading at paragraph 348. There was a scoring exercise which some of them regarded as innocent market testing. But there again, perhaps one is seduced by the fact that, as your lordship puts it, one can turn it into a more glamorous and therefore apparently more manifest error. But at the heart of it, it was a failure to score properly by doing a pretty bogus marketing exercise. That's at the heart of energy solutions, and it will be at the heart of many of the Francovich cases. What the court, in my submission, has to be very careful about is not to say that in order for it to be sufficiently serious, in order to reach the principle of EU law point, it requires something entirely out of the ordinary as far as the nature of the breach is concerned, because that is, as a matter of law, to focus on the wrong thing. The question is, what is the principle of procurement law that has been breached? And that is not the administrative exercise. That's not a principle at all. That's just what you do in order to assess the competition and look for the winner of the competition. It's the award to the correct tenderer that's the principle. If you look for a principle, that's the first one you come to. It's not somehow a higher order thing. And my lords, it can't be the internal market, which was what I thought originally was my learned friend's main argument. As my Lord Justice Coulson pointed out, these two contenders had nothing to do with the internal market. And anyway, as I mentioned in my submissions, unreplied to by my learned friend, the Court of Justice itself in the Cambridge case identifies the economic tenderer as being a central principle of the regulations. So I do say that the difficulty with this is it proves too much, because save in the most egregious cases, it seems, it won't engage the principle. And I ask rhetorically, why does a monstrous mismarking, many large errors in energy solutions, why does that engage the principle of meat when somehow a lesser, maybe one or two, mismarking doesn't engage the principle of meat? Either the principle of meat is engaged because the wrong tenderer has been awarded the contract at the end of the competition, or it isn't engaged. These other matters in relation to the state of mind and excusable errors of law and so on, they arise later on as issues heads 5 and 6 and so on.
Can I just ask one point on that? I mean, if that's right, because that's what the Court of Appeal had said in Energy Solutions, and Lord Matt said, no, you're wrong. I mean, if you're right that a causative breach of the marking always gives you damages, why didn't they just say that in Energy Solutions in the Supreme Court? Because that was the facts of the case.
Because in that case, they never, with all due respect to them, they never engaged at all with the facts of the case. Or it had effectively already been decided.
Yeah, well, and they'd settled. Yeah.
It was tied up and presented as a package, and it was a binary choice for the Supreme Court: press A or B. A, Francovich; B, not Francovich. And that's perhaps a problem with the way that the case developed, whereby the meat of it was, as it were, was decided before the principle of it. But if one listened to the arguments before the court, and as reflected in the judgment, they were at a very high level, a lot around the case of Stat Graz, a lot around how that worked at community level. And nobody asked the court, and it really had no lockers on the matters before it to engage with this issue. So this is, in a sense, now the opportunity to say that. And I invite this court to say it. The fact that they said nothing about Energy Solutions Fraser is helpful and unhelpful. And it's perhaps helpful in this way, and I don't want to overstate it, but at the very least, they didn't say that that which had been done in that case was inconsistent with what they'd found. Now, as I say, not overstating it, but if one looks for a dog that didn't bark, the Supreme Court dog, with respect, did not bark at Mr. Justice Fraser's findings in Energy Solutions below. And so and so there we are. I'll deal as briefly as I can with the other points I had. I was accused of not having identified an analytic failure below in relation to Delaney. I respectfully beg to differ. I identified a series of analytic failures, in particular, the complete opposite of what was said in Francovich about whether one factor can be more important than the others, even decisive. Single error can't be decisive, I heard my learned friend say. Well, perhaps that gives a flavour of the submissions before the judge below. But of course we know from factor tame and Delaney, it can be.
Well, you've made that submission.
Made that submission, but that's my answer to, well, where is the analytic failure? And in fact, there are multiple such failures. Again, the more granular level, my learned friend looked at Lord Hope's comment at page 550 of factor tame and the potential for causing damage, and she said, well, that isn't present in this case. I, again, differ. It should be obvious to the assessors that if they get it wrong, then the rightful winner will be deprived of the contract and the work. So the potential for causing damage, if we're looking at that, and there's no reason not to, is obvious in this case, doesn't require some overarching all-seeing government position. Even the assessors know, especially in a two-horse race, what the consequences if they get it wrong. They know they're doing an important job, and to give them credit, they tried as best they could to do it. They obviously got it wrong in a manifestly erroneous way. So my learned friend was asked about energy solutions because my learned friend's submissions made almost no reference to energy solutions, apart from one perhaps slightly loose sentence in a long and otherwise, in my submission, excellent judgment. But my learned friend markedly did not grapple at all with the many parts of energy solutions that are in my favour and that were simply misread by the deputy judge below. I won't go through it all again, but even if that one sentence in energy solutions was a slightly loose one, it cannot be said, as my learned friend did, that for that reason somehow Mr. Justice Fraser's judgment in energy solutions was founded on some fundamental misunderstanding that means the whole judgment is to be disregarded. Then on effectiveness, I do say that there is an unhappy situation of the law at the moment. I made this point in passing. I will make it as briefly as I can now by reference to the authorities. My learned friend says, oh, nothing has changed about what happens in relation to effectiveness at suspension lifting before and after brace yourself. Well, if we look at what happened before, we see that in Bombardier at Authorities Bundle 2, tab 25. So when this...
Time to look at it. Obviously, it's 4:20, so just give us the references.
Yes.
Tab 2.
Authorities Bundle 2, tab 25.
25, yeah.
And at paragraph 64, what happened post-energy solutions pre-brace yourself is that one conceded that as the law stood, the breach would be sufficiently serious if the wrong bidder was awarded the contract, energy solutions. Now, and the reference is box Authorities Bundle 2, tab 35.
That's not what Lancashire Care says. Lancashire Care is very clear that you have to take into account that it's whether or not it's sufficiently serious.
Yes, but as far as the practice, the unfortunate, I say, practice is concerned, is that now, post-brace yourself, the authority is effectively constrained, if it wants the lifting to happen, to give an undertaking that it won't pursue sufficiently serious at all.
Necessarily, it was going to depend on the facts.
it may do, but that is not what we're seeing. And the example is that in box at tab 35, paragraph 43. And I say that's what I call the DIY solution to the issue, but it's an unhappy one and not one that speaks of an effective remedy.
Okay, so the answer was for this to be dealt with by Judge Bird, and it wasn't pleaded, so you wouldn't have won.
Well, I take issue with that as well.
But isn't that right? I mean, it wasn't pleaded,
Well,
so
damages weren't yet pleaded, but he
Fine.
allowed them in.
fine. He allowed you to plead damages,
Yes.
so therefore you could have had the trial. If he'd been a free, you'd have had the trial Monday, you'd have gone through it, and this point wouldn't have arisen.
Well,
You can't have it both ways.
it
The
wouldn't have
parties
arisen.
can't have it both ways. There's a huge pressure on court resources. Either everything is dealt with initially, or people have to accept that there are different tests at different times.
I disagree with the statement that it wouldn't have arisen.
Well, it hadn't arisen as a matter of fact.
Well, there was a criticism that question had been scored incorrectly, and in fact that remained the nature of the pleading throughout. In the course of the trial, it emerged that there was this particular issue around the stair climb or whatever,
Yeah, which is the key issue for
which is the
present
key issue.
purposes.
It wasn't, I take this as a neutral point, either against or for myself, but it wasn't any more pleaded at trial than it was before. That's a point my learned friend made repeatedly. It emerged around the theme of, and the judge explained it in his judgment, around the theme of what was pleaded, which included, well, it should have been a 4, not a 3. And the judge accepted that the argument had been ventilated before him and he was going to rule on it. And that, in the counterfactual, would have been no different if everything had otherwise gone the same way, if it had been heard the week after or 2 weeks after, or whenever it was. So it does happen that when the witnesses give evidence, something emerges and it is discovered, oh, there was a breach. And so it was in this case. And that would have happened, in my submission, if it had been His Honour Judge Bird hearing it, or if it had been Mr Justice Nissen hearing it a year later, or whatever it was.
Just out of interest, as I understand it, your pleading actually made a whole lot of criticisms about the treatment of the PAL bid.
Yes.
And the manifest errors that that were identified in the pleading of the Braceurself bid were set out in Schedule 1 to the particulars of claim.
Yes.
Which are not in the bundle.
I'm sorry about that. We can.
So I don't actually know.
Nothing very much turns on it. It identifies that we criticise the marking of that question. It doesn't, with any clear particularity, identify the exact breach that was eventually found, but it identifies it in, how shall I put it, in the concept of the fact that something went wrong with this question and the score ought to be increased. That was pleaded. The way that eventuated, given the evidence, was...
I'm just trying to pick up my Lord's question to you, just to make sure we actually have the accurate.
So,
can we just be given the Schedule 1?
yes, I'll just read it and then I'll let you have a copy. Braceurself's bid had clear items relating to accessibility of premises in line with the Equalities Act, in contrast to PAL. There should have been no marking down for the reference to the stair lift. And we'll provide that document. Unless there's anything else, sorry, I was just about to finish the thoughts that I was expressing by saying that in my submission there's no realistic situation where the court at the lifting stage could have expressed a view on sufficiently serious, whether it had been pleaded, not pleaded, or with exact particularity. Given the way that these cases are heard, the court is effectively never in a position to make an ad hoc finding about sufficiently serious without hearing all of the evidence. And that is almost always, almost by rote, at the beginning of these judgments, one sees where the very low threshold of arguability has been met, and let's move on to the rest of American cyanamide. But that just as a kind of practical note. I don't know whether my Lord Justice Dingemans wants me to return to this, but Your Lordship made the point again about damages.
Yeah.
I think that the position here is it's a UK choice that the damages have not been limited. The international position, as we see in the government procurement agreement attached to the WTO, is that there is a minimum idea of just bid costs. That's not how it's been done in this jurisdiction, and indeed, it is probably worth just adding that the government has very recently legislated again on damages in the Procurement Act 2023. Isn't in force, may come into force autumn of next year, and it has not so limited damages. It could have done, it hasn't. And as far as EU law was concerned, it's not only about effectiveness, it's also about equivalence, as we saw in Spiker.
Yeah.
So it has to be effective, it also has to be equivalent to probably the closest proxy, which is breach of statutory duty, which is not limited to bid costs. So I just wanted to, get that off my chest.
So that bill is now an act.
That bill is now an act.
And is there any change to economic operator?
There is a slightly different concept, but not defined. But as far as lifting is concerned, there is still a reference to the adequacy of damages.
Yes. Well, because my recollection is that there were some tweaks which will doubtless become significant when the points arise in practice, to suggest that it wasn't necessarily American cyanamide completely, but there is, but it is generally American cyanamide. Is that a fair summary? That's what I recall of the bill. I haven't seen any, if there have been amendments, I haven't seen them.
There have been no substantial amendments to that part. That is broadly the debate. Is it, it looks a bit different to American cyanamide.
Yeah.
How different it would be for another case.
Yes, and there's from recollection, an enormously long checklist of matters which the judge at first instance has to take into account.
There is a checklist, and they're all qualified by slightly different introducing words.
I shall look forward to those. Ms. Morris, I'm assuming that there isn't anything else you want to say about stair lift, stair climber, rescoring. I'm sure you're not intimidated by me saying I'm assuming that there isn't, but I imagine that all of that ground has been well trampled between you. Yeah, okay. James, anything else? All right, well, thank you both very much, and thank you very much to your juniors and their teams that sit behind you. I meant what I said to my colleague, that this is an interesting case, and so we're very grateful to all the hard work that's gone into it. We will obviously reserve our judgments. You will get those judgments in draft. That's in order for you to correct any minor factual errors and any typographical errors. It is not an opportunity to re-argue this case. The hand down will then be electronic, so there won't be any need to attend. When we send out the draft judgments, we will also send out a letter which invites you to agree the consequential order. If you can't agree, then if there are any matters still between you, you can deal with those very briefly in writing, and we'll deal with those in writing. Finally, as you both know, but I have to say that the draft is only for the people on the list of people that my clerk has to send the draft out to. Nobody else must see it, and as you probably know, there have been a couple of unfortunate situations recently where the draft has been seen by others, and the view has been taken that that is a manifest contempt of court. So can you ensure that it is only seen by the people on the list which my clerk has?
Yes.
Thank you all very much.